The legal war for the McMirich game show concluded today inside the courtroom of Supreme Court Justice Courtney Abel. Last year, Corozal businessman Curtis Dale Swayze took Belize Telemedia Limited and McMirich to court for stealing his game show idea. Swayze told the court that he had developed an idea of a lottery game show involving cell phone texting. He called it Super Slam Sunday. He took this idea to BTL, and over a course of 2 years and 8 months, he had been working with the technical minds at BTL to develop his idea. However, in August 2014, BTL sent him a letter informing him that his game show idea did not fit within BTL goals, and so it was rejected. A month later, McMirich premiered on local televisions, and Swayze then believed that he was bamboozled. Today in court, Justice Abel, who said that BTL and MMR were doing something shady together, ruled in Swayze's favor, awarding him $25,000 in damages. He was represented by attorney Kareem Arnold.
It's a huge moral victory. It's a huge victory on principle for Mr. Swayze. I want to first of all commend him. In my opinion, he's a modern day David that went against the big telecommunications giant, Goliath, BTL. And as we all know who those principals are of BTL and of McMirich, he took on the giants and he came out victorious today. I'm extremely proud of him for taking a stand, because from the very moment I met Mr. Swayze, I knew for a fact that he had been wronged. And it was just a matter of taking it before the courts and presenting the evidence to prove that, in fact, over the course of 2.5 years, BTL manipulated and actually extracted information from Mr. Swayze, and then thereafter shared that information with McMirich. And so today's vindication is a huge victory, and again, I'm very proud of Mr. Swayze for stepping forward.
Kareem, the judge was clearly not happy with the $25,000 quantum that he had to work with.
Yes.
Is there any recourse on your client's part to maybe pursue it a civil matter?
Yes, well, certainly the issue of damages, we have some concern with that. The learned trial judge found that the only evidence before the court was a $25,000 fee that was paid by Mr. Vega to BTL, by MMR to BTL. So there wasn't much else to go on, but our position was that, in fact, the damages that should be awarded to Mr. Swayze should have been based on royalty and to be tacked on to the profits of MMR, because, as you know, well, I don't know if they're still operating, but had they still been operating, then he should have been entitled to a royalty of their profits. There was absolutely no way of us actually getting that information from MMR to see what their profits are. So all we had to go on was based on projections that were provided by MMR. We don't actually have their financials, their statements to show how much profits they've made. So that is a huge difficulty in this case, that we do not have access to their information. So, you know, it could have, had we gotten that information, no doubt we could have gone further.
Attorney Naima Barrow, who represented McMirich, and attorney for BTL, Magali Perdomo, shared their interpretation of the justice's ruling.
It's not a judgment I am comfortable with, would be comfortable taking, but the case is not mine. The case belongs to my client. They were not here today. The representatives weren't able to make it, so I will need to take instructions on what will come of this. But it's not a judgment I would comfortably walk away with and say justice has been done. It's not one of those.
Would you say that this has been a victory for the claimant?
It's a clear-out victory. A clear-out victory. Everything that he has claimed has been awarded to him. Everything, including costs. And he's in a good place sitting down, which is why I think I am so uncomfortable with where we are now.
In your argument in the case, it appears that you and the judge had different interpretations of certain things. What were some of those basic differences of interpreting it?
The difference in interpretation is not it. The law is clear. I think we are agreed on the law. As to the evaluation of the evidence, we are disagreed, and I think in essence what the judge found is that there was some shady business happening between BTL and MMR, because months after MMR's dealings with the claimant ended, MMR's business started. Our case was that they had been in discussions for over a year, so it was not an instantaneous and immediate thing, and the judge never put much weight in it. It's just a matter of that. that the judge found that he was not satisfied that the dealings were above board. The words he used were, I think, shady. So that is his interpretation and reception of the evidence given to him, and it is his right. It is his right as a judge to assess that evidence. His assessment I don't agree with, but that is where we are, and it is the law until something else is done.
I don't know how it could be that the entire company suffers a moral hit because of one claimant and one claim. As counsel for MMR has said, we are all agreed on the law. What we disagreed on was the judge's interpretation of the evidence. And in fact, the judgment does say that the decision was based on circumstances and circumstantial evidence. So it's not a substantial direct evidence. And so I will be speaking to my clients and taking instructions on the appeal. It's not a place we're comfortable with at all.
McMillan remains as an existing company in law, but the game show itself has been put on pause. The last drawing was in September of last year. The directors of McMillan are Andre Vega, the son of Deputy Prime Minister Gaspar Vega, and Sanjay Hochandani.